Privacy laws are those laws which relate to an individual or business entity's expectation to be left free from scrutiny or public exposure in their daily lives, by either the government or by members of the public. While the Constitution doesn't specifically mention a right to privacy, the U.S. Supreme Court has noted in several decisions that it believes that this right exists in the penumbra of several other specifically enumerated rights, such as the Third, Fourth, and Fifth Amendments. As such, it has been held U.S. citizens are entitled to an expectation of privacy under the catch-all provision of the U.S. Constitution's Ninth Amendment, which states, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." So what is privacy? Privacy is the freedom from public scrutiny or exposure, and the rights of information that is collected and used. There are 4 different types of privacy. The first is false light, public disclosure of facts, intrusion into seclusion, and misappropriation. The first one we're going to talk about is false light. False light is an exaggerated or misleading information. The line between defamation and false light can be unclear, but generally, a false light claim is focused on the damage to a person's feelings or emotional well-being, whereas a defamation claim is concerned with the damage to a person's reputation. The restatement offers the following illustration. The plaintiff is a war hero about whom the defendant makes a movie. The defendant adds in a detailed narrative of the fictitious private life of the plaintiff, including a romance. Although the plaintiff is not defamed by the reputation, his reputation is not damaged by the portrayal, he can still bring a false light invasion of privacy claim. New York, Florida, and Texas are the only states that still claim false light. All other states lump false light in with the defamation, since they are so closely related. This is just a little sketch that I found that talks about false light. It says, the publication of facts that place you in false light. Then if a reasonable person objects, it can be taken down. Unless the matter is of public interest, then there must be actual malice involved. The second one we're going to talk about is public disclosure of fact. Public disclosure of facts occur when a person gives publicity to a matter that concerns the private life of another, a matter that would be highly offensive to a reasonable person and that is not of legitimate public concern. A communication to a single person or to a small group of persons is not actionable, since the publicity element requires communication to the public at large, or to so many persons that the matter is substantially certain to become one known of public knowledge. And this is a quote that the book said, and it said, the widespread dissemination that would be highly offensive to a reasonable person and is not legitimate concern to the public. The next one we're going to talk about is intrusion into seclusion. The first element of an intrusion claim is the intentional invasion into the private affairs of another. Courts generally require that the intrusion take the form of a physical trespass. This can be met literally by physically entering onto a private property, or something such as a zoom lens or a highly sensitive microphone to photograph or record a person who has a reasonable expectation of privacy. A court would consider that this is a physical trespass. The second element requires that the actions give rise to a claim that must be offensive to a reasonable person. This requires more than mere discomfort or embarrassment. For example, barging in on someone in the bathroom, photographing them, then using the facilities would be offensive to a reasonable person, while taking a picture of them standing at the mirror combing their hair would likely not be offensive. And then lastly, we have misappropriation. Misappropriation comes from using someone's identity for commercial use without the person knowing. This could be anything from using someone's name to sponsor an item to have a photo of someone who looks like the person being caught. Say you saw someone that looks like Pete Wentz from Fall Out Boy at the park selling drugs. You snapped a photo of him and posted it saying, "Look, Pete is a drug dealer." This would be misappropriation because you have no other facts to back it up. You do not know that it is Pete, other than that it looks similar to him. Here is an example of Zooey Deschanel and Katy Perry. They look very similar, But let's say you thought that Zooey Deschanel was Katy Perry and you claimed something against her. That would be misappropriation. Privacy cases have been litigated for decades. Recent cases and legislative enactments have dealt with these lines between private activities and for those with which an individual has no expectation of privacy. For example, whether store dressing rooms are public or private. There are a lot of gray areas in the laws of privacy, and many incidents have to be dealt with case by case because no one law can really fix the problem.